सुप्रीम कोर्ट ने आर्टिकल 370 की मनसूखी पर फैसला सुनाते हुए दरख्वास्त गुजारों के दलाइल को मुस्तरद कर दिया है और अदालत ने कश्मीर की खुसूसी आईनी हैसियत के मामले पर फैसला सुनाते हुए कहा कि आर्टिकल 370 आइन की आर्जी शक्ति और अदालत का ये मानना है कि जम्मू कश्मीर हिंदुस्तान का अटूट हिस्सा है। वहीं अदालत ने इलेक्शन कमीशन को हिदायत दी है कि वो 30 सितंबर 2024 तक इस रियासत में इंतखाबात को यकीनी बनाए। अदालत की 5 रुकनी बेंच ने सुबह 10:30 बजे अपना फैसला सुनाना शुरू कर दिया और कहा कि 5 अगस्त 2019 को हिंदुस्तान में बरसरे इख्तिदार बीजेपी की हुकूमत ने इंडियन आइन शक 370 के खात्मे का ऐलान किया था, जिसके तहत रियासत जम्मू कश्मीर को नेम खुद मुख्तार हैसियत और खुसूसी इख्तियारात हासिल थे। ऐवान से पास होने वाले बीजेपी हुकूमत के इस फैसले के बाद हिंदुस्तान के जेरे इंतजाम कश्मीर की सियासी जमातों ने उसे सुप्रीम कोर्ट से रुजू किया। चीफ जस्टिस DY चंद्रचूड़ की सरबराही में 5 रुकनी आईनी बेंच ने वाजे किया कि वो जम्मू कश्मीर के मसले पर सदर के ऐलानात में मदाखलत नहीं कर सकते। सुप्रीम कोर्ट ने वाजे तौर पर कहा कि जब कश्मीर को हिंदुस्तान में शामिल किया गया था तो उसकी कोई खुसूसी हैसियत नहीं थी, इसलिए कश्मीर के लिए कोई अलग खुद मुख्तारी नहीं है, जबकि कश्मीर का खुसूसी आइन सिर्फ सहूलत के लिए है। अदालत ने काफी गौर खौस दरख्वास्तों पर समाअत के बाद आज हतमी फैसला सुना दिया है।
All states in the country have legislative and executive power, albeit to differing degrees. The Constitution accommodates concerns specific to a particular state by providing for arrangements which are specific to that state. Articles 371A to 371J are examples of special arrangements for different states. This is a feature of asymmetric federalism, like Article 370, which became applicable to Jammu and Kashmir on the adoption of the Constitution. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. And eighth, the limited question before the Constitution bench in its decision in Premnath Call was whether the monarch held plenary legislative powers after the Constitution of India as it applied to Jammu and Kashmir was adopted in the state, but before the Constitution of Jammu and Kashmir was adopted. A decision is an authority for the proposition which it decides. The question whether the state of Jammu and Kashmir retains sovereignty upon integration with the dominion of India did not arise in that case. The next issue which we have addressed is the challenge to Constitutional Order 273, CO 273. To answer this issue, we had to decide on 2 issues. One, whether Article 370 is a temporary provision, and 2, the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370. We have held that Article 370 is a temporary provision on a reading of the historical context in which it was included. Article 370 was introduced to serve 2 purposes. First, the transitional purpose to provide for an interim arrangement until the Constituent Assembly of the state was formed and could take a decision on the legislative competence of the Union on matters other than the ones stipulated in the instrument of accession and ratify the Constitution. And second, a temporary purpose, an interim arrangement in view of the special circumstances because of the war conditions in the state. See, we have held that a textual reading of Article 370 also indicates that it is a temporary provision. For this purpose, we have referred to the placement of the provision in Part 21 of the Constitution, which deals with temporary and transitional provisions, the marginal note to the provision, which states temporary provisions in respect to the state of Jammu and Kashmir, and a reading of Articles 370 and 1, by which the state became an integral part of India upon the adoption of the Constitution. D. On the second question of the effect of the dissolution of the Constituent Assembly of Jammu and Kashmir on the scope of powers under Clause 3 of Article 370, we have held that the power of the President of India under Article 370, Clause 3, to issue a notification declaring that Article 370 ceases to exist ceases to exist, subsists even after the dissolution of the Constituent Assembly of Jammu and Kashmir for the following reasons. First, the proviso to Article 373, that is Clause 3, encapsulates the process by which the Indian states could ratify the Constitution of India. The ruler of each Indian state had to issue a proclamation ratifying the Constitution on the recommendation of the Constituent Assembly, where such body existed. In states where the Constituent Assembly was not convened by then, the ruler of the state had to issue a proclamation accepting the Constitution. When a Constituent Assembly was convened in those states, the Constituent Assembly could make a recommendation for the modification of the Constitution as it applied to the state, and such a recommendation would be earnestly considered, into inverted commas, earnestly considered by the Union. The words recommendation of the Constituent Assembly, referred to in Clause 2, shall be necessary before the President issues a notification, as it appears in the proviso to Article 370, Clause 3, and must be read in this context. Thus, the recommendation of the Constituent Assembly to begin with was not binding on the President. Second, at the time of the framing of the Constitution of India, it was obviously within the contemplation that the Constituent Assembly of Jammu and Kashmir was formed for framing the Constitution for the state. It was not intended to be a permanent body, but a body with a specific remit and purpose. The power conferred by the proviso to Article 370, Clause 3, was hence something which would operate in a period of transition when the Constituent Assembly of Jammu and Kashmir was formed and was in existence pending the drafting of the state constitution.